has no confidence in Honorable Maneesh Gobin in his capacity as Attorney General and Minister of Justice, Human Rights and Institutional Reforms in view of his role in the matter opposing Jaishwar Raj Dayal to the state of Mauritius with regards to his claims following his removal from Office of Commissioner of Police on the 31st of January 2000.
Madam Speaker, I second the motion moved by the Honourable First Member for Portus Maritime and Portus East, Honourable Shakeel Mohamed.
Madam Speaker, I have come up with this motion that stands in my name, and I've had the opportunity of speaking to many friends on both sides of the House ever since this motion was sent in and circulated with the permission and leave of you, Madam Speaker. And it's clear that in the minds of many on all sides of the House is the following. The question in the minds of all those on both sides of the House is the following. What will this whole motion be about, and how exactly will I try to present this motion to this Assembly? Let me, from the very outset, say the following. The Honourable Member, who is the Attorney General of the Republic of Mauritius, is someone whom I have known for many, many, many years. I have not come with this motion to the House de gaieté de cœur, most importantly because I know the Honourable Attorney General personally. I have had the opportunity of not only knowing him as a politician, but also as a member of the bar. And we have even traveled together. We have shared moments of friendship together, conversations, interesting conversations. And that is why it was not an easy decision for me to come up with this motion. And I will endeavor during this presentation to ensure that I will keep it to the principles that I adhere to. One may not agree with what my point of view is as far as the law is concerned, but I think it is important that I put forward my point of view, and which is in fact the point of view of many, in my humble view, in the country, that there is a decision that the Honourable Attorney General has taken in his advice to government that should not have been taken. And I will explain how this decision was reached at and why, in my humble view, the Honourable Attorney General should not have come to that decision, and the advice that he tendered to government was, in my humble view, the wrong advice. As you will note, this has nothing to do with the person of the Attorney General as a human being, but it's only a matter of principle and the advice that is delivered that I strongly object to. I have always found that whenever there is a motion of no confidence, forgive me if I say that, but in my experience of presenting motions of no confidence, I find that this forces someone to go and make a lot of research. And I believe that it is quite an interesting manner of learning a lot of things. The previous motion of no confidence, I brought in someone to go about parliamentary procedure by reading what happens in other jurisdictions. And in this particular motion that I've come up with, unfortunately the last one could not go ahead because the President of the Republic resigned before I could even come up with a motion. But as far as this one is concerned, it has made me go into a lot of reading and allow me to share it. But I think it is important for us to understand, and for all those who maybe do not realize what is the role of the Attorney General, suffice it to say that it's easy. One goes to the Constitution and one understands what exactly is the role of the Attorney General. Apart from being a constitutional post, He is indeed the principal legal advisor to government and holds the office of a minister. The Attorney General's office is also responsible for drafting of legislation, vetting of all contracts, agreements which government is a party to, including international agreements, treaties, conventions. Those are just but a few of the important role and function of the Office of the Attorney General and the Attorney General himself. I have also read very briefly a publication from the House of Commons, Madam Speaker, and it is entitled Constitutional Affairs Committee, Constitutional Role of the Attorney General, which is the 5th report of session 2006-2007. And in the introduction of this particular document, which is in the first chapter itself, I read, and with your permission, I quote, Professor Dayal stated that one set of relationships in our democracy that has been subject to the most dramatic alteration in recent years is between politics and the law. The appropriate balance between democracies which are in the province of politicians and those which belong to the law is one of the most fundamental questions in all constitutional theory and has great practical importance. What I'm trying to get at here is clearly the Honorable Attorney General is an elected member of this House. He holds the office of Attorney General, but he is also an elected member of the House. And as the Constitutional Affairs Committee of the House of Commons has come up in the publication of 2006-2007, the 5th edition, it is a balancing exercise that one has to carry out. That is not only a balancing exercise that has to be carried out in our jurisdiction, which is also a common law jurisdiction, but it also has to be carried out in many common law jurisdictions, but also non-common law jurisdictions. For instance, here the balancing exercise is the Attorney General has to keep his independence to be able to advise government and should be able to leave aside the fact that he is an elected member of parliament belonging to a political party, thereby his political role. Not an easy task to be able to do this balancing exercise. We have had many attorney generals in our country and many very esteemed attorney generals who have taught us through history that it is indeed possible to balance the two and to put forward the most important element, which is the independence of the role, in order to be able to advise government in an independent manner and to cast aside and to put in a second position and not to give importance to the role of a politician that the elected member also is. And why I believe that it is a very important issue that we address is because it has another piece of, as an introductory element, another piece of publication that I've come across is a book entitled A Higher Loyalty: Truth, Lies and Leadership. It is a book by James Comey, and the author's note makes very important remarks, which I believe is of relevance to our country as well. And I quote, "We are experiencing a dangerous time in our country with a political environment where basic facts are disputed. Fundamental truth is questioned. Lying is normalized. And unethical behavior is ignored, excused, and even rewarded. For some of the crooks, liars, and abusers, there has been a reckoning. For others, there remain excuses, justifications, and stubborn willingness by those around them to look the other way or even enable bad behavior. Ethical leaders do not run from criticism, especially self-criticism. They don't hide from uncomfortable questions. They welcome them. Those leaders who never think they are wrong, who never question their judgments or perspectives, are a danger to the organizations and people they lead. In some cases, they are a danger to the nation and the world. The author in this book, Madam Speaker, talks about ethical leadership. And what I would like us to do as honorable members of this House, even though I do understand that I'm here fighting a very difficult fight, because I have indeed a very steep slope in front of me, that of convincing members on all sides of this House of the importance of this motion. Others may decide that they will stick to party political discipline, whatever be the importance of the motion, and decide to vote against it just for the sake of party discipline. That is a choice and a right they have. But this is a choice and a right, however way you exercise it. History will never forget, and posterity will remember. Responsibility sometimes is put before you in a moment like this. And it's up to you, honorable members, through you I ask them, Madam Speaker, that it is not something that they should take lightly. Because at the end of the day, it is not numbers that count, but it is the truth that counts. At the end of the day, it is not a question of winning votes in this assembly that counts, but it is a question of ethical leadership. That is, does not going to shy away from criticism, but will rise up to the challenge. It is important, in my humble view, to set up the background. Because when I say in my motion, very simply, the role of the Honorable Attorney General in the cases that Jaishwar Raj Dayal, CSK, PDSM, QPM decided to lodge against the state of Mauritius. What were the cases about? And as the motion says, it's about his claims following his removal from the office of the Commissioner of Police. At some stage, after, in this particular case, the person referred to in my motion, Jaishwar Raj Dayal, was Commissioner of Police. That is known to one and all. At some stage, there was a Commission of Inquiry that was set up. Following the Commission of Inquiry, and whatever be the findings of the Commission of Inquiry, also there was a tribunal that was set up. The Commission of Inquiry was presided by the Judge, ex-Chief Justice Bernard Sikwen, and the tribunal was presided over by Raj Malala, also former late Raj Malala, former Chief Justice. I have had the pleasure of reading through the proceedings and the report, most precisely the report of the Commission of Inquiry. And I must say that it is the first time I have read it, even though it was published many, many years ago. It is after those facts that the former Commissioner of Police was fired from his job, if I may put it that way. And finally, it was based on the finding and the recommendation of the tribunal set up by government, by the President of the Republic. But what really surprised me was the statement of the Honorable Attorney General, who chose not to keep quiet, but who chose, and I'm not here to blame his choice or to criticize his choice. He chose, and it's his right, to go out into the public and have a press conference. And he held a press conference, Madam Speaker, to explain the decision, his decision to advise government that it would be fair and good advice and good decision to pay the former Commissioner of Police a sum of money in full and final satisfaction of all his claims. And in that press conference, I have taken the pains of listening to his press conference. and myself noting down every single word the Honorable Attorney General had stated. And he said the following. He started out by saying, this is not a case of payment of damages ou bien interest. He says, I quote, J.R. Dayal, c'est avant tout, dans sa case-là, un fonctionnaire. D'après Solaz, les types retired juillet 2009. Donc, les temps où prend 1999, quand Ramgoulam, pour une raison qui tient dans la tête, prend sa bonne décision-là, jusqu'à 2009, il fait 10 ans. Les temps où prend 10 ans ou multiplié par cela paye, commissaire de police, cela paye, nous tout connaissons, sorti dans PRB Report. Les temps où multiplié par 10 ans, c'est là qu'il va gagner le chiffre de 15 millions. Bien sûr, c'est l'argent du contribuable, mais c'est la paye d'un fonctionnaire, vous autres. Now, in this press conference, what the Honorable Attorney General has stated and explained, because he's dropped his shield, that if one may call it his shield, he's decided to go in public and explain his decision. Why did he advise government to sign this agreement with the Honorable, now Honorable Raj Dayal? And in there, I understand that he states, according to him, that the decision to terminate the employment as Commissioner of Police of Raj Dayal was wrong. What he tries to put forward is that the decision to terminate his employment was a wrong decision. What he says, and I believe here, is that this was the difficulty of trying to balance his role as a politician, elected member, party member, as opposed to that of the Attorney General. What went through the head of the then Prime Minister Ramgoulam, God knows. This is what he's telling us. Because what he is trying to communicate to the public is that it was a decision of the Prime Minister. He does not refer to the sitting of the tribunal. He does not refer to the decision of the Commission of Inquiry as though it never happened. But in actual fact, Madam Speaker, it did happen. There was indeed a Commission of Inquiry. There was indeed findings in that Commission of Inquiry. Findings, and not all of them were deleted or found to be wrong. At a judicial review application, now Honorable Raj Dayal applied for it to be reviewed, and only one part of it was reviewed because it went outside the mandate of the Commission of Inquiry. But 19% or so was still there on the books, and it was tabled in this assembly, and I found a copy up in the library. And it makes a lot of interesting reading, because the impression, nay, not the impression, what the Honorable Attorney General says here is that for him, it was a wrongful dismissal matter. He should not have been dismissed. He should still have been Commissioner of Police. And he would have continued to work for the next 10 years. That is why he advised government that this person should be therefore paid his salary for the 10 years that he should have worked until his retirement age. So in fact what we have is an Attorney General that defies the findings of a constitutional tribunal set up by the President of the Republic under the powers given to him by the Constitution. An Attorney General that decides de laisser sous silence, de passer sous silence the report of Raj Dayal as the person who headed this tribunal. And this is a tribunal set up under the Constitution. The Attorney General has found it fit to go totally against this constitutionally set up tribunal and its findings. The Attorney General decides to go totally against the findings of the Commission of Inquiry, once again set up by virtue of the powers under the Constitution by the President of the Republic, as though whatever has been found in there after months and months of hearing is wrong, does not exist, it never happened. And for him, he believes that it was fit and proper to criticize and cast it aside as though it never happened. When I read the plaints that were lodged by Joshua Raj Dayal against the Commissioner of Police, the State of Mauritius, those were plaints that were lodged in 2014. And in all those plaints, in one of them, Madam Speaker, he makes a claim for 90 million rupees. In another of them, it's only a matter of adding another zero or more and going to 1 billion rupees in 2014. And when I look at the defense that was filed by the Commissioner of Police and the State of Mauritius in this matter, there was a point of law that was raised. En d'autres mots, Madame la Présidente, le commissaire de police comme défendeur and the State of Mauritius as second defendant in one case, and in another matter, the State of Mauritius, in all the matters, those responsible for the state raised the defense. Il y avait une défense. And the defense was that the action of the member was time barred. Time barred. Ce que ça veut dire, c'est que under Section 4.1 of the Public Officers Protection Act, there is the need for the person who wants to complain of an act, of a wrong, that he has to enter that case, and it is a mandatory provision. He has to enter that case within the 2 years of the act, of the wrongful act. When his claim is against the state or the public officers. You have the State Proceedings Act or the Public Officers Protection Act. And there is also the need to serve a mise en demeure, in other words, a written notice 1 month prior to entering his action, in line, once again, of the Public Officers Protection Act. In all those cases, it was time barred. So indeed, there was a strong defense. There was a good defense. There was a defense that could not be beaten. And one goes into, I just also wanted to look into that, Madam Speaker, and I wanted to know, ever since this new government has come into power, how many cases have gone before the Supreme Court where this is the very defense that was put forward by the state under the Public Officers Protection Act and the State Proceedings Act, medical negligence, and I've come across many cases. In one case of the Supreme Court, the case of Siu Sankar versus the state, 2016 judgment. In this particular case, it was about someone who arrived from Dubai, arrested. He was a police inspector, arrested at the airport and interdicted from duty, prosecuted before the ICE Intermediate Court. And finally, he enters a case against the state. And the defense that the state uses, once again, Section 4, because you did not enter your case within the 2 years. And what does Section 4 say? And it's important to remember, Section 4 says that every civil or criminal action, suit or proceedings by a person other than the state for any fact, act or omission against a public officer or a person engaged or employed in the performance of any public duty or a person acting in aid or assistance of the public officer shall, and that's important, under pain of nullity, be instituted within 2 years from the date of the fact, act or omission which has given rise to the action, suit or other proceeding. Under pain of nullity, his case was thrown out simply because he entered the case outside the time limit. Then there is the other case of Somraj Ramnarain versus the Ministry of Health and the State of Mauritius. In that case, it was a plaintiff who had been feeling pain in his right knee. He underwent surgical operation in a hospital, a state hospital. And what did he find when he was taken to a clinic following the operation? That he still, in the x-ray, it revealed that a presence of a foreign body, namely a scalpel blade, was still in his knee. But the state, once again, in spite of that person having a scalpel blade in his knee, medical negligence of the worst type, the state did not win its case on the merits. Ils sont même pas allés sur le fond de l'affaire. Mais on an interlocutory judgment. Once again, Section 4 of the Public Officers Protection Act, under pain of nullity, sorry, you cannot go ahead with your case. Under pain of nullity, the case was thrown out. And once again, Abdul Rafiq, Siddiq Rafiq, same case. Negligence again, under pain of nullity, case thrown out, 2015. Munia, another case, Public Officers Protection Act, thrown out under pain of nullity. Mantrua, sorry. I see my friend Bagwan getting a bit... Baduraj Mantrua versus the Controller of Fire Services. Once again, he entered the case. And he was thrown out simply because of Section 4 and the issue of having to serve mise en demeure, which in all three cases that Raj Dayal entered against the state, in none of them had he served the mise en demeure within the period prescribed, and in none of them had he entered the case within the 2 years. But in other people's cases, the state, in another one, Buna versus the MRA, too bad, you did not enter your case within the period. The notice mise en demeure was not sent. It was thrown out, the Supreme Court. And here, I've only referred to a few cases. And the reason why I'm not going to refer to even more and print out the rest is because my ink in my printer was finishing. And the cases were still there. There were 3 pages of cases listed, Madam Speaker, where the state between 2015 and 2018 have used that as a defense, not even gone on the merits. But my question, therefore, is, when there was such a good defense, when the acts that he complains of date back to more than 20 years back from today, but in 2014 it dated clearly more than 2 years after the fact, when he failed to serve a mise en demeure. If a plea was prepared, si il y avait une défense, and this defense when prepared, Madam Speaker, it is prepared after advice is taken, obviously at the highest level, if not be the Solicitor General himself would give that advice. And this plea will not be prepared and will not be signed by the principal state attorney if there is no defense. This is good defense in law. So if this was good defense in law, en 2015, the defense was filed. In October 2015, this defense was filed, Madam Speaker. This was prepared by the principal state attorney, and it is here signed by the Deputy Chief State Attorney and Attorney for Defendants. And at no time in those cases did Raj Dayal ask for salary should be paid to him between 1999 and 2009. At no time does he ask that salary be paid for him between 1999 and 2009. He doesn't ask for that, Madam Speaker. He simply asks damages and interest. He simply asked because his personal effects are no longer, have never been returned to him. He's asking literally for damages and interest. And none of his claims are for unpaid salary. None. So by what means of a miracle? This is a serious feat. This is something I fail to understand. All of a sudden, there is an agreement that is entered into between Mr. Jaishwar Raj Dayal and the state and others, referring to all the cases is entered into, and in there, this agreement, paragraph 3, I read, had he not been removed from office, he would, in the normal course of things, have remained in office until the 7th of July 2009, date on which he would have retired from office on grounds of age. What, in fact, this paragraph is saying is that, for all intents and purposes, he was never fired as Commissioner of Police. It is here the state stating that for them, he should never have been turned away from his position as Commissioner of Police. Because they not only pay him his salary for 10 years, but they go as far as to pay his pension. Pension, vacation leave, passage benefits, compensation for pension as from 2009, as though he was already all this time still in employ of the state as Commissioner of Police. But what I find interesting in the press conference of the Attorney General is the following. He goes on to say it was not him that obviously computed the salary. It was simply, he says here, c'est le accountant général qui compile en septembre 2013. So this is the political explanation. It is not us. It was computed at the time when the Mauritius Labour Party was in government. En septembre 2013, it's not us. It was computed, and when one looks at the agreement, it refers to another paragraph here. By letter dated the 3rd of September 2013, the Accountant General informs the then Commissioner of Police that he has computed plaintiff's entitlement, which is ex gratia lump sum in the amount of 15,160,782 plus 28 cents, 0.28 cents, consisting of all what I've said, gratuity, pension, reduced pension, etc., etc. By letter of the 28th of October 2013, the then Commissioner of Police, on behalf of the state, offered the sum of 5,723,769.68 as a lump sum payment, which it was declined on the 9th, the 26th, and 27th of May 2000. He declined that offer in 2013. Following him declining the offer, 3 cases are entered, Madam Speaker. 3. And those 3 cases are entered, and a good defense is put in October of 2015. But this agreement is entered into later on. When? It is entered into the 5th of March 2018. Why is it when there was a good defense in 2015? What happened between 2015, October, and March 2018? What happened? Why is it that the defense that held good, that guaranteed that we as the custodians, those who have to ensure that we protect and carry out our duty in a reasonable manner, in a judicious manner, that when we have the responsibility of money belonging to the people of Mauritius in our hands, that we ensure that we don't just, as sometimes said by the Honourable Minister, Right Honourable Mr. Mentor, he likes to use that word and I love it, bangolé. I remember that when he used to say that. And I love it when he says it, and he says it so well. And he's right, we should not bangolé. I remember that from 1995, by the way. I learned a lot. And the good thing is that he remembers how he used the terminology and about whom. That's fair enough. But I love the way he says it. Even now I love the way he says it. It's not a goal. It's a question of me loving it. It's nothing. It's not a game here of winning it. It's just I love the way he says it. Take a compliment. That's it. But what I don't understand is it should not even just be words that applies to only one side of the house. No one should bongole. And in this particular instance, when there is such a good defense, it is bongole when you go and pay someone 15 million rupees or so. Because I remember when I was in cabinet between 2010 and 2014, at no time did government have the right to pay for anything in a claim or come to an agreement in a claim. If the claim for was more than 1 million rupees, you had to have approval of cabinet. Fact. And in this particular case of Dayal, at no time did cabinet approve any payment whatsoever to him, be it for 1 million, 5 million, 10 million, or whatever. Nothing was taken to cabinet, and cabinet never approved anything because at no time was there any request for cabinet to approve. Fact. Never have cabinet been approached between 2010 and 2014 for that, and at no time have we approved anything. Never. Now, whatever offer there may have been, he rejected it. And the offer, if there was, at no time did cabinet agree to it. Had there been an offer that was accepted for 5 million rupees or so, it would have had to come to cabinet. Cabinet would have had to approve it. And once cabinet gave its green light, then and only then there would have been a proper agreement with Mr. Raj Dayal for payment. And this was never the case. But in this particular case, is there a cabinet decision to allow the payment of 15 million rupees or so in 2018 to the former Commissioner of Police? And what disturbs me, Madam Speaker, is the following. And as I said, the background is very important. It's not a simple question like the Honorable Attorney General is trying to give the impression. He gives the impression that simply he should not have been fired. He does not say that there was, as I said, the Commission of Inquiry. He does not say there was the tribunal. But what about the Commission of Inquiry? Why is it that the Honorable Attorney General forgets about that part when he comes to his press conference? Did he not think that it was important to advise government about the findings of the Commission of Inquiry when deciding whether or not to pay? Did he not think it was important for the state attorney when they prepared their defense, because they denied the fact that he was wrongfully terminated? In the defense that was put in October 2015, it is denied. His avaments are denied. The state attorney prepares a defense and denies that he was wrongfully terminated. But here, I think it is important for posterity, and in order to substantiate my motion, to be able to say what is the role he played and what is the role he should have played. How should he have played it? He should have taken into account very important facts that happened in the Commission of Inquiry, that is public document, is now in the public domain, and has already been tabled many years ago on the table of this assembly. And the findings are of utmost importance. Before I get to the findings, the Supreme Court of Mauritius, in the matter 2000, Supreme Court Judgment 2010, record number 69277. This was a case between Raj Dayal versus the Attorney General. In that case, the correspondent was Raj Sumer Lala QC as co-defendant. In that case, it was a claim where Raj Dayal was claiming that there was a refusal of the President of the Republic to furnish him with a copy of the report of the tribunal, which was appointed under Section 93(4) of the Constitution. And in his plaint and in that judgment, he himself, Raj Dayal, says that this document, he should have it because that document recommended that he should be removed from the office for misbehavior. He himself says it in his application. He applies to the Supreme Court, and the reference is 2000 SCJ 210, record number 69277. He makes an application. And the co-defendant is Raj Dayal QC, who presided over the tribunal that was set up under 93(4) of the Constitution, and he says that the recommendation of that tribunal was that I be removed from office for misbehavior. He knows what is in that report, in that recommendation. There was objection on the part of the state. The state said, no, you are not entitled to that report. A preliminary objection was raised, stating that he should not obtain that report. And the state won their case. And I have to congratulate the counsel who appeared for the state against Dayal in that case. It was Maneesh Gobin. He appeared in this matter for the state against Rajkumar Dayal. Rajeshwar Dayal, sorry. And the judgment is dated the 5th of July 2000. He appeared in a case against, and not only that, he was also appeared in the tribunal before Raj Dayal for the state. He was in the team together with the former late Judge Bakor Ali, who prepared the case against Raj Dayal at the level of the tribunal, where the recommendation came out finally. In other words, if we were to simplify it, Honorable Maneesh Gobin as state counsel sustained the charge against Dayal before the tribunal. And today, the same Attorney General goes for a press conference and he says that he should never have been removed from office. Now, I am having difficulty understanding this state of affairs. The difficulty is very simple. One barrister cannot play two sides. You can't. This is called conflict of interest. You cannot appear for the state and prepare the case together in a team, appear in a matter in 2000 on the side of the state against one party, and then later on come to appear for the same party as Attorney General, as friend, as political friend, as brother in the same matter. This is conflict. And if this is the case, which it is the case, then it would be mandatory upon Honorable Maneesh Gobin to have declared his interest. He should have declared his interest, not simply like that. He should have had a register or written declaration of interest in cabinet before he goes to cabinet to get cabinet's green light in order to pay 15 million. That's simple. Now, what I also have come across here is very worrying facts to substantiate it. Why is it that the Honorable Attorney General blacked out the findings of the Commission of Inquiry? Was it not important in deciding whether to pay or not to take into consideration what the findings contained? Was it simply not a way to ensure whether the dismissal was justified or not? How do you ensure that the dismissal was justified? He should have personal knowledge of what it contains, because he was at the State Law Office at the time, even of the disciplinary committee, the Commission of Inquiry. Now, I'll read very important passages, Madam Speaker, that he should have taken into account before advising government. I read from page 10, paragraph 1.1 of the Commission of Inquiry report. In spite of all the trumpet blowing and grandiloquence of the commissioning allocution, it is rather surprising that the Commissioner of Police would have it before the Commission that his role in the ultimate installation of that gate was measurably modest. I'll go to, because if I am to, I know it's a late hour, government strategically decided that this should be taken at this hour, which I respect. I respect. I respect. I respect. I respect. I've said I respect it.
Order, please. Order.
I respect it. I'm here reading a very important part, and this is what I talk about ethical leadership. This is what I'm talking about, ethical leadership. Some people will understand what it means, some won't. I'm here reading at page 185, paragraph 6.1. Mr. Akyao told us that the Commissioner of Police, Mr. Dayal, saw him in his office at Line Barracks sometime before the tenders for 100 motorcycles were launched. Commissioner of Police told him that the police would be buying 50 motorcycles with the possibility of a repeat order. Commissioner of Police asked for a personal commission of 8,000 and an additional one for 3,000 for the quartermaster. Mr. Naiken per motorcycle. This is what the report says. We must add here that all the disclosure about Mr. Naiken's commission came at a second stage, unprompted from the commission. But after Mrs. Manhin had retained the services of Mr. Rajabali of council at the sitting at which they were to face the Commissioner of Police. The confrontation, however, never took place, as we shall explain, because the Commissioner of Police, in our reckoning, showed the white feather. And it says here, Mrs. Manhin cleared their check, 9,996,000 on the 29th of January 1996 for the sale of 40 motorcycles. On the following day, they drew two cash checks of 320,000 rupees and 120,000 rupees each, which were exchanged at the State Bank of Mauritius. Mr. Akyao stated that he personally remitted the sum of 120,000 in cash to Mr. Naiken when the latter called at the office of Monsieur Manhin in Port Louis. With regards to the Commissioner of Police cut, Mr. Clément Manhin stated that he met the Commissioner of Police at a pre-arranged meeting at the Continent filling station. At Phoenix, the Commissioner of Police came in his car accompanied by one of his sons. Mr. Manhin then followed the CP's car in his own car, meandered through the several off-track roads until he reached the CP's house. The sum of 320,000 rupees was then remitted to the CP in cash. Was this challenge before the Supreme Court? Was he successful about challenging that part at the Supreme Court in the judicial review? No, he wasn't. It still is in the report. And the Supreme Court has stated that this will stay in the report. Mr. Naiken. And then he goes on, with regard to the CP's share, Mr. Thierry Manhin, Mr. Clément Manhin's son, stated that he was requested by his father to call at Line Barracks to remit an envelope to the CP. He called there, announced himself, and was received by the CP. He didn't have to wait in the corridor. He remitted the envelope to the CP, and the latter, after checking the contents, a cash check, returned the check saying, cash only. Mr. Thierry Manhin then retrieved the check, had it cashed at the bank, and came back to pay his dues to the CP. The relevant notes of evidence of Mr. Clément and Thierry Manhin and Mr. Paul Akyao were communicated to the CP and the quartermaster, and those witnesses were made available for questioning at a subsequent sitting. I would have said maybe that was from one witness. But then, is there not more? Then there is more. In another chapter, entitled The Revelation, Page 203 of the report, paragraph 2.1. In a gist, Mr. Eric Lille stated that he had not told everything he knew at the earlier sitting of the Commission because he feared physical retaliation. He revealed that by the end of June 1997, the Commissioner of Police had called one of his employees, Mr. Bernard Colette, and had requested the payment of a commission on Land Rover and Opel vehicles which had been sold to the police by Lille and Co. Subsequently, on the 1st and 11th of July, two sums of 225,000 rupees and 400,000 rupees respectively were remitted in cash to the CP in the latter's office in the presence of Mr. Colette. On the second occasion, a lunch was offered by the CP at the police mess at Line Barracks. From a canteen requisition, sheets obtained from Corporal Vaitilingam, we have seen some of the culinary likes of the CP. Camarons, more than 12 pounds of fish, 2 packets of prawns, and a turkey weighing 16 pounds. And we go on. Mr. Lille gave some details about those sums, but at the subsequent sitting of the 27th of November, qualified some of the answers he had given earlier. He explained that it was clear from the specifications of the vehicle that it was tailor-made for him. But who had sent those tailor-made specifications to the Commissioner of Police to tailor-make it? Indeed, as mentioned earlier by Mr. Labat, the General Manager of Azas was quite candid to admit that the specifications of then Land Rover had been communicated to the police by Azas prior to the call for tender, and that to his knowledge, Land Rover was the only maker for 4x4 jeeps with an aluminium body. Mr. Lille decided to give 15,000 rupees per unit. That was probably because of the little miseries shown him by the Commissioner of Police in not postponing the tender to January, when the sole agency would have been firmly in his hands. In this document, Madam Speaker, the same report, why is it that on 2 instances from Mr. Manhim and his employees coming to a Commission of Inquiry and saying to the Commission of Inquiry, we admit having given money to the Commissioner of Police as commission because the Commissioner of Police set le barème and he asked for it. This is what they say at the Commission of Inquiry. Did the Honorable Attorney General not think it important to at least let the court decide? He decided to take it upon himself to cast aside strong law defenses in law as far as the Public Protection Act is concerned, and the need to serve a notice mise en demeure, strong defenses in law put up by the state attorney. He decided to cast it aside, advise government that it was right to pay. Did he not think that it was important to draw the attention of his colleagues that this is what there is as a background? Was it not important? Was it not important? I'll not refer to the paragraphs concerning the children or family members of Raj Dayal out of respect for those people. But here, I'll read page 370. And page 370, it says here, paragraph 16, we reject the explanations that the funds came from income derived from agricultural exploitation by the Dayal extended family as unconvincing and untrue. We simply do not believe that the CP's uncle would play Father Christmas. Nor do we believe his brother Satish, who like his elder brother came up with the same story that he also exploits of land of 90 perches but could not give us any convincing details of the exact location of the plantations and the workers who were supposedly employed to till the land. Nor are we gullible enough to swallow the CP's story of agricultural prowess on his plot of land of 25 perches at Karolalian, which is the very land on which he has built his house, so that the area available for plantation must be pretty scarce. What is interesting, Madam Speaker, what is interesting is that money, I'm not saying here that this is the truth and nothing else but the truth. And I want to be fair. I'm saying here that this is a true background. Whoever sat at the level of this Commission of Inquiry, 3 persons chosen under presidential intervention with strict parameters, made those findings, people deponed. And here I have to refer to this very interesting remark about the revelation again, about how one of the, at these days, this is quite stressful actually, when Mr. Leal was questioned by Mr. Liang Xing, late Mr. Liang Xing QC. Is it not late? Oh, sorry. So it's early, therefore. My mistake. So Mr. Liang Xing QC, and I read here at page 208, Mr. Leal movements as well as the time he had received the visit of Mr. Ducret on the Wednesday the 25th and on Thursday the 26th were being put to him point blank by Mr. Liang Xing QC. This prompted the witness to tell counsel. Mr. Eklil turns and tells counsel Liang Xing QC, mais, Monsieur Liang Xing, vous connaissez tous mes mouvements. That brought a cackle of laughter from counsel, and the Commissioner of Police looked at the witness with glee. The Commission felt that the crude message that was being conveyed to the witness was that Big Brother knew each and every of his movements, and that he should better watch out what he says. And now, page 211, Mr. Colette said something about his having received a phone call that morning reminding him that he had a child studying abroad. At first blush, that statement appeared to be rather incoherent. But then Mr. Colette had awkwardly added that he would prefer not to say any more until he had checked with the person who had spoken to him. The Commission insisted on a full and immediate disclosure. We learned then that Mr. Colette had received a phone call that very morning, approximately at 11:30, and he was told to be careful of what he was going to say before the Commission, since he had a child studying abroad. This is the background. If I'm going to refer to how much money was collected in coins, from where, and how it was cashed in his personal accounts and of his sons, I better not go there, because it would go on until tomorrow night. And I could go on and on and on and on, but this is what was forgotten. I hope I'm right. Simply forgotten, not, I hope, not on purpose by the Honorable Attorney General. Because it would be dangerous for this country that the Honorable Attorney General has decided not to inform his colleagues and not to rely on this very important elements before coming to some sort of decision as regards advising government to sign an agreement to pay someone 15 million after all that I've just read, which is only about 1% of what the Commission of Inquiry found against Raj Dayal. In conclusion, the Commission of Inquiry has a chapter 8. And I read page 417, paragraph 1.0. The Commission feels that the CP, the QM, and the officers of the customs named in this part of the report may not be the only ones who have accumulated such levels of cash and other assets. There seems to be sufficient evidence to demonstrate that such practices are all pervasive among certain groups of officers. What the Commission of Inquiry asks, in fact, is that there should be investigation, that there should be prosecution. People should pay. People should pay for what they've done. Yes, it's true that he was prosecuted, but how many years later on? Why is it that finally the police dragged their feet to inquire into this matter? Why is it that the police dragged their feet before sending the file to the Office of the Director of Public Prosecutions. The Commission of Inquiry and the tribunal finished its work. And who came to power? Who was Prime Minister? Dragged its feet. And when each and every time I hear Honorable now Raj Dayal say that he won his case, the case was dismissed. Not on the merits. Not on the merits of what he was charged with. The case was dismissed because there was an abuse of process. In other words, it was abusive to come and prosecute someone after so many years. That is how he won his case. True. But the fact remains, the background is still there. The background of the Commission of Inquiry was still there. The strong defense in law in line with the Public Officers Protection Act was still there. The State Proceedings Act was still there. The State Attorney found on the merits in the defense of October 2015 that there was good defense on the merits. They denied that he was put out without justification. They denied that he should be entitled to any damages and interest. They denied in law as well that he should go forward with that case. They denied it. Why, therefore, did my good friend, the Attorney General, not use this as a background before advising government? And what makes matters worse, I'm sure other members would talk about that after me, is that not only, and I repeat that the Honorable Attorney General as State Counsel was in the team that appeared at the tribunal, he also worked together with late Judge Bakor Ali on this file at the tribunal chaired by Radsume Lala QC, as he was then. But he also appeared as counsel for Raj Dayal in the case at the Supreme Court against Advance. So, as I said, not only was there the need for him to declare his interest in the first instance as having been counsel working on the charges against Dayal, Commissioner of Police, but he should also have declared his interest when it comes to him having appeared for Raj Dayal in a matter against Advance. He is a good lawyer. He won the case against Advance. Congratulations. But my issue is not to do with him as a person. Because as I said, and I come back on that again, the problem with our society is that we have forgotten that we don't have all to agree and that we have to be able to remain friends by not agreeing. Not a very easy thing to do in our society because it's maybe out of our culture. We have to be able to debate ideas, principles that should not make us enemies. So as I said, I have not at all flinched from what I say. I know him personally. This is nothing to do personally against him, but as Attorney General, there are certain things he should have done and there are certain things he should not do. Now he will come later on, Madam Speaker, and say, but the Labour government advised to pay 5 million. The answer is never did government advise and authorize the payment to Raj Dayal because it never came to cabinet, and had it come to cabinet, I can speak for myself, I do not believe that I would have gone for that. I can speak for you as well, and you will say so. We would not have stood for that. Because there is precisely, sans vraiment descendre and making it personal, there is this background that dates to times when I had just started practice in the legal profession. I have nothing to do against Mr. Dayal. It's nothing personal against him. But this exists. So what are we to turn around to say? The Honorable Attorney General, a constitutionally appointed Commission of Inquiry. We cast it aside, throw it aside. Taxpayers' money were paid to the Commission of Inquiry, President and its assessors. Who cares? A tribunal set up. I'm sure paid as well. But who cares? He has decided that he should not have been fired and his salary should have been paid. Based on what is he going to tell us? That he cast aside the Commission of Inquiry report, the Tribunal's report, the defense in law, and the defense on the merits. How did he cast that aside? And the testimony of Mr. Lille, the testimony of Mr. Manim, the testimony of Mr. Colette, the testimony of Mr. Labat, all saying one thing, that the Commissioner of Police asked us for commission, and not only did he ask, he mentioned the figure, and we went to leave the money in his office, and he even verified that the exact figure was there, and he took the money and offered us Cameron in return. Is this how we are going to be the principal legal advisor? Of course not. I hope it has nothing to do with the fact that Honorable Raj Dayal is a member of Parliament on government side. I hope it has nothing to do with the fact that he belongs to the MSM. I hope it has nothing to do with the fact that he is no longer minister. I hope it has nothing to do with the fact that he could easily, out of disgust, resign and thereby provoke a by-election. There comes again the importance of the balancing exercise between the role of the politician, the party man, as opposed to that of the independent advisor. I've said what I believe are matters of principle, and I've said it without fear or favor. And now, the time will come where all those before me who have listened to me on all sides of the House, and there, Madam Speaker, I speak to every one of them. I speak to every one of them because it's important. Maybe they were not aware, my friends, the honorable friends, were not aware what was in that report, because I myself had not even read it. I have gone through it. I have the report here. I can give it to my friends for them to verify what's there. If you don't believe me, go to the library and check it. It's there. It's in there. Use the resource of this National Assembly. Read, Madam Speaker, is what I ask my friends to do. And know that this is the background of this case. And know that as guardians of the people who voted for you, you have the responsibility of ensuring that this background is not simply cast aside because he's your friend. Friends tell the truth to one another, and they do not shy away from the truth. Because as I said, later on, down the road, questions will have to be answered. Why did you allow it? Now, it may mean that your party will be angry with you, but history will not. It may be that the Prime Minister was not aware of all this, and I would love to believe that. I would love to believe that he was not informed of all the background. I sincerely, for the love of our democracy, would love to believe that. And there I come to ethical leadership. What do we do in a situation like this? Thank you very much.
I suspend the sitting for 10 minutes.